Good afternoon. My name is Olena Shaltsova. I am an immigration attorney from Brooklyn, New York. Today I would like to speak with you about inadmissibility. Inadmissibility is a legal bar for a non-US citizen to come to the United States on a visa or to adjust status to one of a permanent resident. Inadmissibility findings are usually done by a consul or adjudicating officer from USCIS. What to do or what can be done, if anything, when a person is found inadmissible? First of all, a person should find out what exact basis for inadmissibility was found is applied to him. For a visa applicant, it should be a written denial notice. For an applicant for adjustment of status, it should be a written decision that denies inadmissibility on a specific basis. A basis of inadmissibility is very important because it determines whether a person can file for a waiver of the basis, whether there was a mistake, can a person ask for a consideration, maybe a person should reapply for the same visa or the same application, file the same application that the person already filed, or maybe a person should ask for an advisory opinion from a visa office in DC. There are many different bases for inadmissibility. They can range from something like security grounds, from which usually there is no waiver, or it can be something that a person can apply if the person is eligible for a waiver, let's say criminal ground of inadmissibility. It can be something very serious, like accusation of misrepresentation or fraud made on a visa application, or it can be something less serious that the person can still deal with, but it requires some work. So first of all, the person should get written decision which specifies the basis for inadmissibility. For some grounds of inadmissibility, as I said before, there are no waivers. Let's say consul believes that a person is engaged or is affiliated with organized crime. There is no waiver of inadmissibility for this basis of finding. What a person can do in this situation is, of course, a person has to consult with an attorney. And if the person believes a mistake was made, what a person can do is to file for a rebuttal. Usually, this finding comes from information contained in files of Department of Homeland Security. The source of this information is usually confidential, and the person should contact the department directly through an attorney, trying to explain that a mistake was made and trying to convince the Department of Homeland Security that the person is not in fact engaged in any sort and it has nothing to do with organized crime. The success of this application will be based on how convincing the evidence will be. It's a very difficult situation because here a person has to guess based on what particular occasion and based on what information Department of Homeland Security concluded that the person is engaged with organized crime. Same goes for terrorism findings. When a person is believed to be somehow related to terrorist organizations or is supporting such organizations. So it's not an easy task and it's not an easy basis to overcome, but sometimes it's possible. Easier situations involve criminal grounds of inadmissibility. Let's say a person was convicted of a crime of moral turpitude in their home country, but even though conviction is from their home country and not from the United States, it still can be basis for finding that the person is not admissible into the United States. Depending on what visa, what type of visa, immigrant or non-immigrant, the person is applying for, there are different types of waivers that can be available to this person if the person meets other qualifications for a waiver. Some grounds of inadmissibility are very wishy-washy. Let's say a person is applying for a non-immigrant visa and consul believes that the person does not have sufficient ties with his or her home country. And even though the person presented records of person having some real estate in his home or her home country, that the person has family and the person has sufficient assets, consul still believes that this applicant has immigrant intent. That finding is very hard to beat usually, because even though the person can, under the law, go to visa office and ask for advisory opinion under the circumstances, advisory opinion people usually would say that the consul has a better the consul is in a better position to determine whether or not that particular applicant has sufficient ties with his or her home country. I would not say that such cases are hopeless, because it would not be true, because we were successful in reversing some of the determinations, but they're definitely not easy to deal with. And it requires work of experienced and hardworking attorney who's also smart and can analyze the situation and see a bigger picture, and will be able to convince other people who are adjudicating the application, to convince them that the person actually met requirements for visas and let's say adjustment of status application. If you are looking for more information on the issue, please visit our website www.shoutsova.com, and you also should follow our blog. It's www.russianspeakinglawyer.ny.com. Thank you.